Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information plenty of bad folks would rather you not have. Today, ladies and gentlemen, we'll be providing another installation to our Anti-Federalist Papers series going on number 61. So if you haven't gone back and watched 1 through 60, I would highly encourage you to do so because understanding the Anti-Federalist Papers, in addition to the Federalist Papers, will provide you a very well-rounded understanding of the U.S. Constitution, and understanding the U.S. Constitution will be absolutely necessary if you intend to combat any sort of lawfare waged against you, your loved ones, or your hard-earned property. So let's go ahead and jump on over to the Anti-Federalist Papers. The version I'm using is provided by the constitutionalistsociety.org or .com. I forget which end URL they use. But you can also find it in a number of other different institutions, both in a digital and paper format. Go ahead and get both formats. Good grief, gotta untie my tongue. Both formats, just in case you can't access one or the other for whatever infinite number of reasons. And while you're out there looking, if you haven't done so already, go ahead and get a paper and digital copy of the Federalist Papers so you can join us in comparing and contrasting the arguments for and against ratifying the U.S. Constitution. Excellent. So number 61 is titled Questions and Comments on the Constitutional Provisions Regarding the Election of Congressmen. It is well observed by Montesquieu that in Republican governments, so it looks like it's going directly into what this Anti-Federalist had to say. Usually this compilation has a preface it provides a little bit of context of the Anti-Federalist paper about to be displayed, but it looks like this one's going directly into it. So this is what the Anti-Federalist had to say. He says this: it is well observed by Montesquieu, we're definitely going to be going over his work in the near future, that in Republican governments the forms of elections are fundamental, and that it is an essential part of the social compact to ascertain by whom, to whom, when, and in what manner suffrages ought to be given. Wherever we find the regulation of elections have not been carefully fixed by the Constitution or the principles of them, we constantly see new legislators modifying their own form and changing the spirit of the government to answer partial purposes. By the proposed plan, it is fixed that the qualifications of the electors of the federal representatives shall be the same as those of the electors of state representatives. Though these vary some in the several states, the electors are fixed and designated. The qualifications of the representatives are also fixed and designated, and no person under 25 years of age, not an inhabitant of the state, and not having been 7 years a citizen of the United States can be elected. The clear inference is that all persons 25 years of age and upwards, inhabitants of the state, and having been at any period or periods 7 years citizens of the United States may be elected representatives. They have a right to be elected by the Constitution, and the electors have a right to choose them. This is fixing the federal representation as to the elected on a very broad basis. It can be no objection to the elected that they are Christians, pagans, Mohammedans, Muslims, or Jews, that they are of any color, rich or poor, convict or not. Hence, many men may be elected who cannot be electors. Gentlemen who have commented so largely upon the wisdom of the Constitution for excluding from being elected young men under a certain age would have done well to have recollected that it positively makes pagans, convicts, etc. eligible. The people make the Constitution. They exclude a few persons by certain descriptions from being elected, and all not thus excluded are clearly admitted. Inclusio unius, exclusio alterius. Very important legal concept that we've done a lecture on. Please go watch that lecture. One of the most important, especially in the context of the Western jurisprudence. Now a man 25 years old, an inhabitant of the state, and having been a citizen of the state 7 years, though afterwards convicted, may be elected because not within any of the excluding clauses, the same of a beggar, an absentee, etc. The right of the electors and eligibility of the elected being fixed by the people, they cannot be narrowed by the state legislatures or Congress. It is established that a man being, among other qualifications, an inhabitant of the state, shall be eligible. Now, it would be narrowing the right of the people to confine them in their choice to a man, an inhabitant of a particular county or district in the state. Hence, it follows that neither the state legislatures nor Congress can establish district elections. That is, divide the state into districts and confine the electors of each district to the choice of a man resident in it. If the electors could be thus limited in one respect, they might in another be confined to choose a man of a particular religion, of certain property, etc., and thereby half of the persons made eligible by the Constitution be excluded. All laws, therefore, for regulating elections must be made on the broad basis of the Constitution. Next, we may observe that representatives are to be chosen by the people of the state. What is a choice by the people of a state? If each given district in it choose one, will that be a choice within the meaning of the Constitution? Must the choice be by plurality of votes or majority? In connection with these qualifications, we must take the fourth section, Article 1, where it is said the state legislature shall prescribe the times, places, and manner of holding elections, but Congress may make or alter such regulations. By this clause, I suppose, the electors of different towns and districts in the state may be assembled in different places to give their votes. But when so assembled by another clause, they cannot, by Congress or the state legislatures, be restrained from giving their votes for any man an inhabitant of the state and qualified as to age and having been a citizen the time required. But I see nothing in the Constitution by which to decide whether the choice shall be by a plurality or a majority of votes. This, in my mind, is by far the most important question in the business of elections. When we say a representative shall be chosen by the people, it seems to imply that he shall be chosen by a majority of them. But states which use the same phraseology in this respect practice both ways. I believe a majority of the states choose by pluralities, and I think it probable that the Federal House of Representatives will decide that a choice of its members by pluralities is constitutional. A man who has the most votes is chosen in Great Britain. It is this, among other things, that gives every man fair play in the game of influence and corruption. I believe that not much stress was laid upon the objection that Congress may assemble the electors at some out-of-the-way place. However, the advocates seem to think they obtain a victory of no small glory and importance when they can show with some degree of color that the evil is rather a possibility than a probability. It is easy to perceive that there is an essential difference between elections by pluralities and by majorities, between choosing a man in a small or limited district and choosing a number of men promiscuously by the people of a large state. And while we are almost secure of judicious, unbiased elections by majorities in such districts, we have no security against deceptions, influence, and corruption in states or large districts in electing by pluralities. When a choice is made by a plurality of votes, it is often made by a very small part of the electors, who attend and give their votes, when by a majority, never by so few as one half of them. The partialities and improprieties attending the former mode may be illustrated by a case that lately happened in one of the Middle States. Several representatives were to be chosen by a large number of inhabitants, compactly settled, among whom there were 4 or 5,000 voters. Previous to the time of election, a number of lists of candidates were published to divide and distract the voters in general. About half a dozen men of some influence, who had a favorite list to carry, met several times, fixed their list, and agreed to hand it about among all who could probably be induced to adopt it, and to circulate the other lists among their opponents to divide them. The poll was opened, and several hundred electors, suspecting nothing, attended and put in their votes. The list of the half dozen was carried, and men were found to be chosen, some of whom were very disagreeable to a large majority of the electors. Though several hundred electors voted, men on that list were chosen who had only 45, 43, 44, etc. votes each. They had a plurality, that is, more than any other persons. The votes generally were scattered, and those who made even a feeble combination succeeded in placing highest upon the list several very unthought of and very unpopular men. This evil never could have happened in a town where all the voters meet in one place and consider no man as elected unless he have a majority or more than half of all the votes. Clear it is that the man on whom thus but a small part of the votes are bestowed cannot possess the confidence of the people or have any considerable degree of influence over them. But as partial, as liable to secret influence and corruption as the choice by pluralities may be, I think we cannot avoid it without essentially increasing the federal representation and adopting the principle of district elections. There is but one case in which the choice by the majority is practicable, and that is where districts are formed of such moderate extent that the electors in each can conveniently meet in one place and at one time and proceed to the choice of a representatives. When, if no man have a majority or more than half of all the votes the first time, the voters may examine the characters of those brought forward, accommodate, and proceed to repeat their votes till someone shall have that majority. This, I believe, cannot be a case under the Constitution proposed in its present form. To explain my ideas, take Massachusetts, for instance. She is entitled to 8 representatives. She has 370,000 inhabitants, about 46,000 to 1 representative. If the elections be so held that the electors throughout the state meet in their several towns or places, and each elector puts in his vote for 8 representatives, the votes of the electors will 99 times in 100 be so scattered that on collecting the votes from the several towns or places, no men will be found, each of whom have a majority of the votes, and therefore the election will not be made. I might add many other observations to evince the superiority and solid advantages of proper district elections and a choice by a majority, and to prove that many evils attend the contrary practice. These evils we must encounter as the Constitution now stands. I see no way to fix elections on a proper footing and to render tolerably equal and secure the federal representation, but by increasing the representation so as to have one representative for each district in which the electors may conveniently meet in one place and at one time and choose by a majority. Perhaps this might be effected pretty generally by fixing one representative for each 12,000 inhabitants, dividing or fixing the principles for dividing the states into proper districts, and directing the electors of each district to the choice by a majority, of some men having a permanent interest and residence in it. I speak of a representation tolerably equal, etc., because I am still of opinion that it is impracticable in this extensive country to have a federal representation sufficiently democratic or substantially drawn from the body of the people. The principles just mentioned may be the best practical ones we can expect to establish. By thus increasing the representation, we not only make it more democratical and secure, strengthen the confidence of the people in it, and thereby render it more nervous and energetic, but it will also enable the people essentially to change, for the better, the principles and forms of elections. To provide for the people's wandering throughout the state for a representative may sometimes enable them to elect a more brilliant or an abler man than by confining them to districts. But generally this latitude will be used to pernicious purposes, especially connected with the choice by plurality, when a man in the remote part of the state, perhaps obnoxious at home but ambitious and intriguing, may be chosen to represent the people in another part of the state far distant, and by a small part of them, or by a faction, or by a combination of some particular description of men among them. This has been long the case in Great Britain. It is the case in several states. Nor do I think that such pernicious practices will be merely possible in our federal concerns, but highly probable. By establishing district elections, we exclude none of the best men from being elected, and we fix what, in my mind, is of far more importance than brilliant talents. I mean, a sameness as to residence and interests between the representative and his constituents. And by the election by a majority, he is sure to be the man, the choice of more than half of them. Signed, the Federal Farmer. So, ladies and gentlemen, that is all to be said in number 61. If you have any questions about what was said in 61, maybe questions about what was said in the preceding papers, or if there's a topic you'd like me to cover in a future lecture, go ahead and post those down in the comments, because the entire purpose of the Calhoun School of Law is to provide you with the necessary skills and information to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope y'all have a wonderful day, and I'm not sure what the topic for the next lecture is going to be, but I'll do my best to make it as informative and entertaining as this one, if not more so. Regardless of the topic of the next lecture, until I see y'all then, I bid you all farewell.